Well, thank you for that generous introduction, and thank you to those who invited me to come here. It's great to be back in Arkansas and to not have to come up here for a football game like we used to have to do in the Southwest Conference days. And it's always good to meet with people who are interested in our state judiciary and the rule of law. There are some students here who did not have the benefit of this morning's proceedings, so maybe I'll say something they haven't heard before. For the rest of you, just bear with me for a while. And we'll try to leave some time for questions and answers and thoughts, because I think some good ideas have developed in our morning seminar out of the exchange between the audience and the speakers about trying to find some problems to some very difficult solutions to some very difficult problems. It's always easy to see the time you live in as being the most important or the most critical, but I do really think that our state judges, particularly elected state judges, are facing some rather unique confluence of pressures right now. For one thing, there are more hot-button issues coming before the courts than ever before, or at least than a generation ago. A lot of this is due to legislative buck passing. I mean, why make a bunch of enemies on an issue like same-sex marriage if a court will maybe take that burden over for you? But a lot of it is just due to litigants thinking creatively about what our constitutions say and don't say, about maybe how the common law ought to be developed. And then a lot of it is just the over-legalization of our society, as it were. A lot of issues that might have been handled by the family or the church or the school principal in times past now come before the courts, and the courts make a decision that makes somebody unhappy, not just a litigant, but frequently the people who get a 5 or 15-second rendition of that case on TV news that night. The second thing that continues to happen at an accelerated pace is that more and more money changes hands in judicial decisions. As the world gets smaller and the United States has a reputation for courts that are honest and relatively prompt, and the procedures are relatively transparent, we get more and more big litigation. And most of this is in state courts, because that's where 95 to 98% of the business is. And it's estimated that $50 to $80 billion a year changes hands as a result of judgments or settlements that have been brought in the American court system. So there are winners and losers in this process, and more importantly, people who want to be winners or losers in the future. And they are interested in affecting who sits on the bench, naturally enough. And in states with elected judges, there's a way that you can have an impact on that. So it seems to me that these two trends, that is, hot-button issues coming before the courts that people have an interest in, and lots of money changing hands, typically over rather arcane issues of interpretation of the law that people don't have much interest in, have merged together over the last few decades. And not to be too blunt about it, the participants in the tort fights are pouring a lot of money in judicial races with messages that talk about guns and crime and family values and abortion and other hot-button issues for which most judges probably never, at least on those social issues, they may go an entire career without ever rendering a decision on it. So we have, in short, what Chief Justice Randy Shepard of Indiana talks about as the judicial branch being political roadkill on the way to larger objectives by political parties and political consultants who use public interest or outrage over some judicial decision in order to drive turnout up and down the ballot for candidates of that particular party or interest group's choice. This trend is accelerating across the country. In the 1980s, there were some particularly bitter judicial races. The retention election in California, when Rose Bird and some of her colleagues were on the ballot. Classic example of a tort fight being played out on criminal law issues. And then in the late 1980s in Texas, where I had the honor of being part of that, and I was kind of, for a few moments, kind of the most expensive judicial candidate in history, but I'm a footnote now. But people said, you know, that's just those particular states. Texas is always going to be an outlaw, and California just had an aberration. And in the 1990s, it came to Alabama and to Mississippi, and well, they are easily explained away too. But in the last decade, this has become a nationwide phenomenon. What Professor Shotland said this morning, what did you say, Roy? Traveling road show or something like that? Better, yes, traveling auction. As seriatim, most states that have elected judges have faced these issues of large outside money and a lot of rather vitriolic advertising campaigns in an attempt to influence who sits on the bench. Cultural problems, I think, in society have exacerbated the difficulty of the ordinary sitting judge in responding to this nationwide phenomenon. We'll go through these. First, we talked about this morning quite a bit, lawsuits over the last 10 years, starting with the White decision, Republican Party of Minnesota versus White at the U.S. Supreme Court in 2002, which struck down a narrow little provision in the Minnesota Code of Judicial Conduct that purported to keep judges from speaking out on public issues, although it was never enforced and was an obsolete provision. Inventive lawyers have come in behind that decision and struck down far more vital parts of traditional regulation of judicial speech that states had thought they could do because of the compelling state interest in keeping judges fair and appearing to the public to be fair and impartial. But we are learning, at least in some areas of the country, otherwise. And in Arkansas, you're curiously in the 8th Circuit, which seems to be virtually any state they don't know what to do with gets put in the 8th Circuit. And that circuit is perhaps the most expansive in the nation in saying that an individual's free speech rights should not in any way be curtailed just because they want to sit on a dais with a guaranteed salary and have a robe that allows them to take away your life or liberty. So while the Arkansas Supreme Court has been a mainstay in articulating the reasons why somebody who wants to wear that robe might have to keep some of their views to themselves, this has not found favor in the federal courts, and because of that little war you lost, we do have a supremacy clause issue there. And we have to be mindful of these legal developments. Secondly, and this is even broader, for most of our republic, the bar leadership, the worthies, as it were, have had a big influence on who gets to be a judge and who runs. And most judicial races, nearly all the time until recent years, were unopposed. Maybe when there was an open seat, there'd be a race, and maybe a judge who'd done something really stupid could get an opponent, or in Arkansas, you don't let your appointed judges run, but in Texas, it was kind of okay to run against a newly appointed judge. But after somebody had been elected once, you just had to kind of stay out of jail, and you were pretty well guaranteed of running again. And the local bar would support you, the newspapers would support you, the community organizations, and you were in the club. And a challenger who tried to buck up against that would have no funds and very little way of getting a message out and very little support among the community. A lot of things have caused that to change. One is just there's a lot more judges in most places, and unless you are in a fairly small area, it's hard to know who all your judges are. In Harris County in 1994, known to Houston as some people, 55 contested judicial races were on the ballot, and I venture to say nobody knew who the 110 candidates and was able to evaluate who was the best in each individual race. So since we have partisan elections, people just pulled a lever and hoped they'd send a message to the top of the ticket and went home. And we lost about 500 years of combined judicial experience in that sweep. So that's one thing. But I think even more pervasive is the decline in respect for authority figures. And this has been particularly precipitous in just the last 3 or 4 years. You see this being played out in our presidential race. Folks figure if the smart people sat around and decided a real good idea was to make loans to people who couldn't afford homes and then bundle them up and sell them and resell them and resell them and cause a worldwide depression as a result of that, you know, they just as soon trust somebody picked out at random on the street to make major policy decisions. And there's almost a hostility now to experts or people who've given careful, nuanced thought to a problem. And there's a cry for simple answers by someone who hasn't thought about the problem very much. In the 1980s in Texas, when we were developing a two-party system all the way up and down the state, in most of our urban areas, the straight party lever pool we had was pretty closely divided between Democrats and Republicans. And about 10% of the people on a good day would split their ticket by the time they got as far down as judicial races. If you had the support of the Bar Association, which invariably ran polls, and the newspapers, and local community groups that made endorsements and sent out cards, you won. And so the judicial candidates focused their attention in campaigning on these opinion makers, tried to win those types of endorsements. We then went through a period in Texas when most of our urban areas were Republicans, and it didn't matter about those cards so much. You were playing to whichever group was important in your primary. But now we're back again. Houston, Dallas, San Antonio are very competitive between Democrats and Republicans. So the older folks like me remembered what had happened in the 80s and said, we're going to do it again. We'll run a bar poll. We'll get lawyers to volunteer at every polling place in the county, you know, and then print their name at the bottom, brought to you by your friendly lawyer. Hand these out to people. Get the newspaper to endorse this slate of who the bar's for. And even though we have a lot of yo-yos running for judge, the better qualified candidate will win in each race. Well, guess what? Times had changed. It didn't work. It didn't work at all. There were no more than 50 or 100 votes out of 1 million that were swayed by that card. People were swayed by whether your name was short or long, ethnic or generic, male or female. In primaries, they were swayed by whether you were on the top of the ballot or not. But they were not swayed by what some opinion leader had told them to think. So we are in a position, I think, where a lot of sitting judges feel like sitting ducks. Circumstances well beyond their ability to have any influence over may determine whether or not they get to continue in their role or not, and whether or not their successor is competent or not. And it feels more like a crapshoot than an intelligent choice by those who ultimately are in charge of our democracy, the people, to decide who should sit in judgment over them. Well, what are people trying to do in response to some of these problems? One has been a renewed push for the appointed retention election system called merit selection. This was thought up in the late 19-teens by a group called the American Judicature Society, kind of at the tail end of the progressive reform movement. It was supposed to get a list of qualified people in front of the governor who would choose one as judge, and then that person would take office, judge for a while, and then run periodically on a yes-no ballot to keep their job. After World War II, it looked like this method of choosing judges was going to sweep the nation. And it was kind of interesting because how you select judges was kind of the last great unsolved puzzle in how the basic structure of our state governments worked. I mean, we started off after the American Revolution with governors being chosen in a lot of different ways, with a lot of different looking legislators, some unicameral, some bicameral. And all that kind of got, over time, people got into the idea of a 2- and then a 4-year term for governor who was elected independently of a legislature and then 2 houses of the legislature, generally copying the federal system. But no system of selecting judges ever really took hold and carried the day. Appointment or election by the legislature for the first 50 years of our republic kind of vied among the different states. Then we went after 1846, there was a period of about 40 or 50 years when popular election of judges, either generally partisan, was the way every new state and most of the old states thought you would choose your judiciary. There was a revulsion to that, basically because of what some of the big city political bosses were doing selling judgeships and other unsavory things. So reformers came up with nonpartisan elections, and those worked better except in the large urban states where the ballot was completely anonymous. And so this merit selection idea came along. From 1959 to 1977, 18 states adopted it, but it slowed. And I think part of why it slowed was this reaction to the idea that the elites know better than we do about who should hold power in our society. New Mexico in 1988 adopted a partial merit selection system. No other state has done so since then, although there have been incredible pressures in the 1990s and 2000s to adopt this system in a large number of states, and it's gotten on the ballot to either adopt it or extend it in 5 or 6 states, and it's lost in every one, and it hadn't lost close. So in 2000, you changed your constitution to go to nonpartisan, which I think was a real good idea just in the nick of time from what I experienced in Texas. And you also allow the legislature to put this merit selection on the ballot when it wants to. I would say don't do it yet. Don't do it until, as in Oklahoma or Florida, half your Supreme Court goes off to prison, and I don't see any volunteers now among the justices who are here to give that kind of impetus to the movement. But wait until there's a little more trust in our government before taking your shot on that. I say nobody's adopted merit selection. Actually, to be exact, in Missouri, they have a local option, and Greene County, Missouri, in 2008 went to merit selection. The largest county in the state that still elected its judges popularly, but they're the only ones. About half the southern states have gone from partisan to nonpartisan like you did in Arkansas. And that's been an important reform, but not one that gets you all the way home, as you can see. The other idea that's been bandied about that some people advocated at one time was more public funding. There again, not many people want to see their tax revenues going to campaign consultants and media buys. Most states have tried to do this through some kind of lawyer occupation tax, or court fee system, but it's really only in place in 3 or 4 states. And the only new state that's done it in a big way successfully has been North Carolina, which switched first to nonpartisan. North Carolina had like the most screwball system in America at one time. They nominated all their trial judges in local districts, and then they all ran statewide, which was advocated obviously by whichever party was ahead at the time. So all the judges were of one party or the other, generally Democratic. And the Justice Department was taking a dim view of that, so they've started making reforms under some pressures from above, but they've done quite a good job. But it has not been emulated anywhere else except a little bit in New Mexico. So another idea that's people have said, maybe we're stuck with whatever selection system we've got in our state, and it could get worse if we try to tinker with it, given some of the forces out there. So there have been a lot of talks about campaign finance reform. States that did not have limits, like Texas, imposed them for judges. You already have limits in Arkansas. I gather they apply to all public officials, and the judges were fortunate enough to be swept in. There's been a lot more attention to disclosure, getting information out about who is actually contributing. And this is pretty easy to do in terms of direct contributions to judges. It's been harder to do, or states have been less willing to do it with independent expenditures. And you have not had any of that in Arkansas, but a lot of states had. I had it 25 years ago in Texas when just some ads popped up from nowhere with a Constitution burning, and they said, "This is what Tom Phillips has in mind for you." And it took a while to figure out where that money was even coming from. One effort that's been tried in some places is longer terms. Given what I've said about public reaction to the elites taking away their power, you can guess how the public term movement has gone. It's lost whenever it's gotten on the ballot. One thing that has not much been tried is higher qualifications for judges. I mean, obviously, if you're a judge, usually you'd like to keep your job, particularly if your pension hasn't vested. But for the system's sake, if your successor is equally or better qualified, there is no harm to the administration of justice. But if your successor's a buffoon, that's a problem, more than just for you. So most states have certifications for people that have practiced for a certain number of years and have accomplished, a certain number of things. If you could raise the qualifications for a judge, and you might have to raise the salary at the same time, but that's another story, then maybe it wouldn't be so important if these elections were anonymous or not. But that has run into a lot of opposition. First, it generally takes a constitutional amendment. Secondly, in those states under Section 5 of the Voting Rights Act, as you all are not statewide, right? But we are in Texas. You can't change those. You cannot change a qualification for an office if it would skew who would be eligible to run. And in fact, under Bush 41 administration, there was consideration of filing suit in Louisiana against its constitutional requirement that general jurisdiction judges be lawyers, on the philosophy that there were not enough black lawyers in Louisiana at the time to fill the judgeships in places where they might be elected. And so under the Supremacy Clause, we just shoved that little issue of legal training aside. And so, I mean, the federal government does obviously think of its goals as more important than a state's particular goals in areas. So no state that I know of has enhanced its qualifications to sit as a judge, even as these elections have heated up. But I think it's something that if you can do it in your state, it bears looking at. Another effort, which has been done in a number of states and with some good results, is to try various means to get the voters more educated. Frankly, we have had judicial independence in America for so long that we take it for granted. That's not true in the rest of the world, where the great move as freedom has extended around the world in the past 60 years has been to give courts independence in order to protect people's freedom and give them a right of judicial review over the laws that are passed by the legislative branch. When democracy first started opening up in the world, as the British and French colonies retreated, the big mantra of the UN and of America and other countries was democracy. We'll give everybody the vote. But in far too many countries, there was one election. And the winners said, okay, here's the new law, no more elections, or elections with only one party. As the world grew smaller commercially, World Bank, IMF said, here's a good idea, why don't you go invest in XYZ country? And sometimes they said they've even got a democracy. And the answer that came back from the multinationals is, yes, but our contracts won't be enforced. I mean, we may go invest $1 billion and our property will be expropriated. Or we may have a supply deal with the Prime Minister's brother-in-law, and when they don't pay us, we aren't ever going to get any money. And so these twin problems of protecting people's basic freedoms and protecting their economic enhancement both came to be seen as being better served by the rule of law than purely by giving people the vote. And so across much of the world, people really do appreciate what judges are doing. But we've had it so long for here, we take it for granted. And we don't realize, I mean, you expect the judge to do the right thing, and so the news is when the judge does the wrong thing. But groups that explain the importance of independent courts and why in the long run, we're all better off, even if a court occasionally misreads a statute and applies it the wrong way or strikes something down that we think ought to be upheld. In the long run, we're better off to give judges that power than we are to take it away from them, is something that takes some explanation and re-explanation. Justice O'Connor's been very active in trying to reinstitute civic education into our school program that got taken out for various and sundry reasons, some good, some bad over the last generation. But you know, we're now left where more people can name the Three Stooges than can name the three branches of government, and that's not real good when it comes time to vote for who your judges should be. A lot of states have tried something that I personally was skeptical of, but it has worked well, and that is to have informal, non-government affiliated committees created that monitor judicial elections and call candidates out or call special interest groups out when they make statements that are insupportable, unfair, or misleading. I'm convinced that most people want to do the right thing when they go in and vote for judges. I know in my home state, nicknames work a whole lot better in a legislative race than they do in a judicial race. Like if you're named Tex or Butch or Hang 'em High or something, that's probably an advantage in a legislative race. It has not tended to be an advantage in a judicial race. I get the sense people do see that judges are different, and in the long run, they're better off if the judge is trying to follow the law as made by the people in their Constitution and by elected representatives in the legislature than a judge who's just, you know, calling them, looking at a morning poll and trying to call them like will seem to be popular. But they don't have a lot of information, and so the more you can get the information to the people in a painless way, the better off you are. About 5 or 6 states have a state-funded voter pamphlet that goes out in the fall before the election. In California, the candidates pay for it themselves, and that's its own problem. To buy, if you're running for a trial bench, to buy a place in the voter pamphlet in every language that you need to be in is well in excess of $100,000. So you've got to go out and raise a whole lot of money just to get in the pamphlet. But in states where this is state-funded, it has been a real boon, and surveys show that's what people rely on most. For instance, in Washington State and Oregon and now in North Carolina, they're looking at their pamphlet to get information to make that decision on who to vote for judge. But it's got to be short and nice pictures and easy enough that people will take 5 or 10 minutes to look at it before they go to the polls. As I've mentioned, we need more disclosure about who's giving money to races and who's trying to help whom. In some of these high-dollar races that you haven't had yet in Arkansas, but that we've had in so many other states, the candidates' funds are limited. And candidates are reluctant to take money from people with active cases in front of their courts or even from law firms that have a huge amount of business before a court. Outside PACs have no such limitations, and frequently they dwarf the spending of the candidates themselves. In Michigan in 2008, I believe it was, about $10 million was spent on their judicial races. A little less than $10 million. But anyway, a quarter to well under a third of it was spent by the candidates themselves. And the candidates were generally running informational type ads like, I'm smart, my opponent's stupid, and I've had 20 years experience and they've had 2. And, you know, a little nasty, but grounded in some truth. These independent ads were fantastic. I mean, they're very entertaining, but they're not grounded in any truth. There's one I remember where 2 guys they're taking crates down from a warehouse, and they say, "Hey Al, where do we ship these dangerous machines?" "I'll ship them to Michigan. The Supreme Court says you can get maimed and killed and you can't be sued for it." And now on the other hand, both sides always run ads about some criminal who's only been given 50 years when they could have been given 52, and they go out and commit another crime. But just knowing where that money's coming from, and in fact that those criminal ads are always from your friendly plaintiff's trial lawyer or your friendly chamber of commerce. If that's prominently mentioned enough, people can discount that. This all seems kind of boring sometimes, particularly to those of us who are not in the legal business or in public affairs. But I close with saying that I think the main thing we need to do is explain to people in every way we can why this is so important, that our judges have the independence they need to apply the rule of law for the protection and prosperity of us all. We laugh when we look at some other countries, and I have this old clip. It's now 10 years old, but it's from China. And it says, in the wake of the Tiananmen Square affair, China abandoned any pretense of following the rule of law. Mr. Rex Jinzing, president of the Supreme People's Court, has said flatly, various levels of the People's Courts must self-consciously accept party leadership. It is a mistake to think that because there is the law, justice can be executed without the guidance of party policies. Well, we think this is our great advantage as Americans. We don't have our parties, telling the courts what to do, and therefore maybe we don't have the most natural resources, maybe we don't have the cheapest, and maybe even not the best educated workforce, despite the best efforts of the Clinton School and others. But you don't have to pay bribes to the policemen, and you can get your contracts enforced in court. But then I look back at Governor Gray Davis, whom you may recall said, judges who I appoint who don't agree with all of my policies should resign from the bench. Or you look at a resolution passed by the Republican Party of Texas that 2 Republican judges who voted to strike down the state's anti-sodomy law, which eventually they were affirmed and it was struck down by the U.S. Supreme Court. The Republican Party demanded that they resign because they did not follow the principles in the Republican platform. And you realize that this is a slippery slope, and that our biggest competitive advantage for the 21st century, which is the fact that we have rules and you know what they are and the people follow them, can be jeopardized. Not all at once, not in one fell swoop, but just slowly nibbled away by the exigencies of the moment, by somebody trying to gain an advantage here or there. And so, for those of you who are engaged in a public service career, the judiciary is not just some boring part of the administrative state over on the side that, if you're lucky, you will never, have any first-hand acquaintance with. But this is really at the core of the American experience and what's made our country distinctive and different. It's the part of the American governmental structure that everybody else is trying to copy. Why they don't want the president and Congress fighting each other to a standstill, I can't figure, but they don't. But they do want the independence given to our judges. And I think we have a responsibility, really not only to ourselves, but the whole rest of the world, to protect what Chief Justice Rehnquist called the crown jewel of the American experiment. Thank you. I'm going to go.
All right, we have time for some questions. If you would raise your hand, and we'll get the microphone to you if you have a question.
If you're getting CLE credit and you don't ask questions, I'm just going to start talking about something. So.
In this crowd of lawyers and judges, and there is a question. Wait, the microphone's coming to you.
An underlying theme seems to be that you can't let the people have the judges they want. Am I reading this wrong?
Well, I think so. Contested judicial elections are a very hit and miss thing. First of all, even in the most highly contested states, statewide, most races are unopposed most of the time. And I don't think that's because the judges are so great that they'd get 100% on the ballot if they had an opponent. I think it's like one of my friends said after he escaped opposition, he said, plenty of opposition but no opponent. And I know in Texas you have to file for election a year before you take office, and that keeps a lot of people out of the race if they're in a small jurisdiction. If you're in a large jurisdiction, as I've said, you just don't know who you're voting for. But I really think if you believe in the popular control of the judiciary, that you're better off with a nonpartisan race or with the merit selection system where every judge has a yes or no vote than you are with a hit and miss filing like we have in Texas. You know, I think a lot of the good for the election comes in the effect it has on the judge. And there have actually been studies that judges take shorter lunch breaks and are nicer to jurors and all if they have a filing deadline coming up within the next 6 or 8 months than if they've just escaped the hangsman's noose there. So I think reminding the judge who the ultimate boss is frequently as important a part of this election process than letting the people go look at a mass of anonymous names and pick one out. Now, you may be from an area where everybody knows who their judges are, and if you do, God bless you. And I think that system works better than any I can think of. It's just a declining part of America today.
Yes, you have a question right here.
I think he wants a rebuttal.
Well, that's okay. Let's go around. We'll give him a chance here in a minute. Go ahead, Kathleen.
In Arkansas, the judges are elected at the time of the primary, and then if there's a runoff, it's in the general election. Do you have any studies or any information or thoughts on whether it should be at the general election when there are more people voting than in primaries or vice versa? Just comments.
Well, it's been tried various ways in various states, and particularly when we first went to elections in the 1850s and 60s, they tried having a separate ballot just for judicial races. Well, guess what? No, you know, it was hard to get even people to run the polls, much less to come vote. So I think it ought to be at a time when you have more voters coming out. I would hope in a state like Arkansas you still had a pretty good primary vote. I mean, in Texas, obviously the number of voters in the primary used to dwarf the general election because that's where the action was. It's changed now. We have about 3 times as many general election voters as we have primary voters. So if we were going to have a nonpartisan race, I think it would depend on whether you think most of your races are going to be decided in a two-way race or in a runoff. And if you're going to have if the majority of races will be multiple candidates and you need a runoff, I think the way you've set it up right now is right. Have that runoff be in the general election. If, on the other hand, it's the other way and there never is a 3 or 4 person race, you might consider moving it.
Yes, we have a question right here.
First, a disclaimer, I'm not a lawyer.
Good for you.
Well, I wanted to ask, you mentioned finding qualified candidates to run. Is there any chance that the tendency toward trial lawyers pushing more cases toward bench rather than jury trials could affect the people who choose to run if this tendency continues?
Well, I wasn't aware of that. I mean, we haven't had the tendency in our state that I know of.
Well, there was an article on NPR yesterday about that in New York, for instance.
Is that for a faster result, or they just think the judge may be friendlier?
No, I think it was that the jury pools were not educated enough for complex cases and so on, and that judges were finding themselves handing down decisions on more of those cases.
Interesting. Well, that's a good question, and I really don't know. I haven't thought about it, and even if I did, I'm not sure I'd come up with the answer. My sense was that, well, I know this, when a federal bench comes open at home, there's always 90 or 100 applicants for it. And we generally have, 2 or 3 candidates at best for an open judicial seat. So there's something unattractive about the state courts. Our pension system's better than the feds, at least it vests quicker. the cases would seem to me in many areas to be more interesting than a lot of what the federal judges have to do. So the election must have at least a part of it in there. Now, whether people run for judge because they want to be making those tough factual determinations or not, I don't know. I mean, I found the intellectual challenge of ruling on evidence, which you don't do in a non-jury trial. You let everything in and say the law indulges in the presumption that if it's irrelevant, I will ignore it. The intellectual challenge of ruling on all the evidentiary points and then crafting a jury charge for the case that's both correct and isn't going to get you reversed. You know, it's not going to get you reversed and will get you the right answer in the trial. It seemed to me was at least as invigorating as trying to decide who was telling the truth and who was lying, which I always felt I was not nearly as good as a jury at, but that I was better at them in following the evidentiary rules. So I'm not sure. I sense that people may be pushed towards the bench by the increasing difficulties in law practice. And they're repelled from the bench by elections and the fact that in most places salaries have been pretty flat for a good while.
Questions? Any other questions? All right, you got your rebuttal right here.
By the way, I hear you were a very good judge in Texas, but...
Yeah, keep talking to those people.
Okay. A part of the voter's dilemma seems to be that you can be told very little about the thinking of a judicial candidate. The very thing you want to know is where does he stand on abortion, or what's his view on state taxes, or whatever. We can know all those kind of things from the president down to the precinct candidate, except if he's running for court. Do you have any thoughts about how to remedy that, or whether it even needs to be remedied?
Well, there are competing interests at work here. You do not want a judge trying to act like a one-person legislator. I mean, the judge's personal views, we would hope, are irrelevant, except their personal views on whether they're going to grant a continuance or not when what excuses will work and which ones won't. I mean, you want the judge following the law because making up their own rules, they're just very poorly equipped for it. They don't take testimony. Trials are never about what's the best for society as a whole. It's always about, this one particular case, so you don't get a broad view of things. You don't have the governor right to a veto or a second house or just the wisdom that comes from the large group. And, of course, basically you don't have the rule of law if judges are just importing their whims into their decisions. On the other hand, if you have a judge who is going to do that, I would like them to tell me that before they get a full term. So I think that the restrictions that we try to have on judges committing in advance to how they rule is important for them to remember how they're supposed to act and for the people to remember what the role of the judge is. But giving a judge enough wiggle room to run out, as one of my opponents did, and say, I'm always going to vote for this party in this particular kind of case is kind of good, because then if you're in the side that's lost before you start, you can move to recuse that judge with some degree of success. But I think, on the other hand, I don't want to make light of your question. I have seen judges hide behind that code of judicial conduct whenever any tough question comes along, like, well, how come you only tried 8 cases last year? Well, I'd love to tell you, but the code keeps me from going into those issues, which, of course, it doesn't. Which is some states have actually started schools for judicial candidates and their managers, and I think that's a pretty good idea. If at least the candidate's running in good faith, to sit and talk for a day or two about what kind of questions can I answer and can't I answer. And I think judicial philosophy, not tied to any one case, is a legitimate thing to talk about. And of course, in America, we have at least two widely differing views, broadly stated, about what is proper for a judge to do, and they now split among the people and among the parties. The most fascinating poll I've seen in recent times was in September of 2008 from Rasmussen. And it asked McCain and Obama voters about their views on the courts. And I remember that only 11% of McCain voters thought that a judge's principal job is fairness, whereas 59% of the Obama voters thought that. And so, you know, tremendous split in how people with different political, and both of those views are, you know, broadly stated. I mean, the Scalia and the Breyer view of constitutional interpretation, statutory interpretation, everything else are valid in the American system. So I think a discussion along those lines is very helpful. I think every drunk driver is going to get the maximum sentence no matter what, or those people in Washington haven't been able to stop abortions, but you can be sure that there won't be any in Pulaski County. I think that's unhelpful, and it's beyond the judge's role, but that's not always an easy line to draw.
I want to thank the Administrative Office of the Courts, J.D. Gingrich, the Arkansas Bar Association, Tom Womack, Justice Brown, and Justice Phillips. Thank you very much for being with us. Thank you all for coming.